What, to your knowledge, triggered that? Was there any intervening circumstance, fact, or piece of evidence that was adduced that would cause the department, after this case had been postured in a fashion so that it was poised for for default judgment, to reverse its position, or at least reconsider its position? What instrumentality, what intervening circumstance occurred?
The acting assistant attorney general wanted to make sure that she had a complete understanding of the facts and circumstances of the case. And I'll note parenthetically, this wasn't the only case she was working on. She was running a fairly robust division, and so she concluded that she needed an extra 2 weeks in order to make a judgment that would be a judgment on the merits, wherein she had considered all of the evidence in the record.
Wasn't the evidence considered beforehand?
The evidence was always being considered throughout, but as of May 1st, the judgment was made that I still need some time to weigh the evidence and make an appropriate judgment.
And I suppose she then solicited the opinion of the 6 line attorneys, career attorneys, who were heavily involved in the case, correct?
Well, there was a robust internal debate during the course of this and throughout.
Okay, so I take that to be a yes.
Whenever you have decision-making in any case, you have interaction between the front office and the people who are involved.
So you have 6 career attorneys heavily invested in the case, all of whom were sought out. And in fact, my understanding is their opinion was sought out not once but twice. They provided memos indicating that their position remained firm, that default judgment should be pursued, and yet something happened. And that's what I think we're trying to figure out. What intervening circumstance, given the fact that the momentum throughout had been to go forward with this case, what was the trigger?
Well, I have great respect for all of the attorneys who were involved in this case. And I have certainly had cases where I, as the frontline attorney in the case, wanted to go one way, and at the end of the investigation, the people above me in the career ranks of the chain concluded that based on their experience they wanted to go another way. As I've said a number of times, people of good faith can look at the same set of facts and draw different conclusions, whether it's Pima County, whether it's Mississippi, whether it's the new Black Panther Party case, and again, 2 people with 60 years of experience, both of whom had worked in the voting section, so they weren't new to voting rights issues. They were working. They knew, they were conversant with the issues, conversant with the case, and they made the judgment on the merits that we should proceed with the default judgment against the gentleman who had the stick, and that the evidence didn't sustain the case against the National Party or the head of the National Party for the reasons that we've discussed.
If the evidence was such that it was maybe not nearly an equipoise, but it was a close case. In fact, you've got 6 line attorneys who are fairly adamant that there's enough to pursue here. If there was concern that default was not the appropriate
I'm sorry, Commissioner Kirshner, we'll have to follow up next round. Vice Chair Thornstrom?
Thank you very much, Mr. Chairman. First, let me make a statement to clarify something. I have not asserted that this incident was frivolous. But it would have made a difference to me in terms of making it our statutory report if there was a national conspiracy, if new Black Panther Party members were showing up all over the place, if there was anything remotely equivalent to racist whites in the Jim Crow South stopping voters from being able to cast their ballots, and that analogy has been made by some members of this commission, and I simply object to it. So I never have called it frivolous, but now, do you think that there has been a difference between Republican and Democratic administrations in their concern about the confidentiality of attorney work products? That's question number 1. And 2, with respect to 11B, are there guidelines upon which the department relies in enforcing that provision?
As it relates to your first question, this confidentiality interest in not disclosing internal deliberations has been an interest that has been put forth and put into play in Republican and Democratic administrations alike with an equal amount of vigor, because there's a recognition of the institutional interest as the Department of Justice in ensuring that we have a robust internal decision-making process. And so I saw it because I was a career person. I was hired by the elder Bush administration, and I saw the assertion of that interest then. I saw the assertion of that interest under President Clinton. I see the assertion of that interest now. I think it's a good interest. I think it's a critical part of what enables us to do our job. And I respect the job that you have here, and I respect the job that people in Congress have, and that's why I'm here today, and that's why we've taken so much time to do that. In response to your second question regarding 11B, there's a paucity of case law and a paucity of cases that have been brought under this. And intimidation has been, there are jury instructions that define intimidation in other contexts, right. And those contexts have been instructive to the work that we do here. And what those jury instructions in other contexts highlight is that it is indeed a high bar, and it's very fact intensive, and that is why it's difficult it's fact intensive, and it's simply difficult to prove. So
there are no internal guidelines, but there are cases.
We have cases. We also have, again, we have guidance that is informed by our enforcement of similar statutes, right, that proscribe coercion, intimidation, right, and attempts at those issues.
Mr. Chairman,
Commissioner Gaziano and
yielding your time.
The full 5 minutes.
Okay. When earlier in January of this year, when the then outgoing voting chief, Chris Coates, was leaving, there was a farewell farewell reception in your division. I know you attended early, and you, as I understand, may have left before he gave some very well publicized farewell remarks. The summary of those remarks was published by, written up and published by, of the remarks, and he implies that he believes the new Black Panther case was dismissed because there are some in the department who don't think the Voting Rights Act should apply even-handedly across the races. And I'm glad that you've said that you disagree with that. I haven't talked to Chris Coates because you won't let me. The department won't let me. So I don't know what the basis of his belief is in that regard. But what did you do, if anything, to investigate whether there was any basis for his view?
Again, I reviewed the facts and circumstances of this case. I have. I didn't
ask my question very well. Did you do anything specifically after Chris Coates' statement in January to see if his impression that the decision was motivated in part, or at least in part, by a race-based view of civil rights enforcement? Did you do anything to investigate whether there was a basis for his claims?
I have reviewed the totality of the evidence in this matter because I wanted to make a judgment.
So you did nothing. I hear from that that
sir,
you did nothing. You're not answering my question.
You're not giving me a chance to answer your question, sir. And if you want to keep interrupting, that is obviously your prerogative.
Because you've said you have such a limited time with us today, I really would ask you to, well, let me move on since you won't answer that question.